This is in the District Court of Butler County, Kansas. Cases entitled in the matter of the marriage of Stephen Michael Booth and Sarah Ashley Booth, case number 24 DM 128. Would the parties announce appearances, please?
Elena Hoyle with Kansas Legal Services on behalf of Sarah Booth. She's present before the court.
Shannon Cooper appears as guardian ad litem for the children.
Mr. Booth appearing pro se.
All right, thank you, everyone. We're set today for a status hearing. We last appeared back on April 7th and took up several issues regarding motion to compel, a contempt issue. We set today over for further hearing on the motion, the contempt motion. Since that time, each party have filed a number of motions as well. This morning, I also received an updated report from South Central Mental Health. Ms. Hoyle, did you receive that as well?
I did, Your Honor, and I have had a chance to read it.
All right, and Mr. Booth, did you receive that?
Yes, Your Honor, and I've reviewed it as well.
All right. I think what I'd like to do is, first of all, get an update on the status of how everything's going. Ms. Cooper, from your perspective as guardian ad litem, and then we'll kind of address the motions. I don't know, some of these are ones that maybe we can address as part of this status hearing. Others might need to be set over for evidentiary hearings. Ms. Hoyle, have you and Mr. Booth had an opportunity to have any sort of communications on resolution of any of these outstanding issues?
I know we've discussed in the past several times some of the issues that he's put in his motion. My issue is that we have not been able to come to an agreement on whether or not he should be paying child support throughout the pendency of this matter. And I think that's the reason why we would need to have that motion on file. With regards to the sale of the residence, we have discussed that as well in the past. This has been a point of contention as well. Another reason we need to have that, if we need to have an evidentiary hearing separate than today's hearing to discuss these matters, then I'm more than willing to do that at a later date if the court is wanting to do that instead of today.
Okay. Well, like I said, I think some of these we might be able to address. If you all hadn't had an opportunity to speak yet or thought if going into a breakout room would be productive, I would allow some time to do that. In the interest of perhaps you aren't as far off as you think you are, perhaps you can come to some agreements. If you all don't think that will be productive, then I'm not going to force you guys to do it. Your thoughts, Mr. Booth?
Your Honor, I would prefer that if there is any sort of discussion that it be conducted with a court-appointed mediator.
Okay, well, I'm not going to do that. I was just going to see if there's a chance you all could have some settlement negotiations, but it doesn't sound like that's going to happen. So, Ms. Cooper, if you could provide an update on how things are going from the children's perspective at this time, please.
Thank you, Your Honor. So as everybody's aware, I received an update from the therapist. I think based on her recommendations that the children be afforded more time with dad in order to basically see how that goes is my understanding, and also to potentially progress further in therapy. That would essentially be my recommendation right now. I anticipate in my report and recommendations that I would offer that and see maybe essentially increase parenting time with dad gradually, just to see how that progresses and see if they can continue to make progress in therapy. I don't think there's any reason to stop the family therapy. It seems like it's going quite well. We did look up Dad's, I think this is the court for Dad's criminal case. Looks like it's set for status later this month. So I'm not sure where that case is heading or what's going to be happening as far as that goes. That could potentially have an impact on parenting time. Also, some of the filings I've read in our case, I'm not sure what's going to be happening as far as Dad's living arrangements. That could impact, what my recommendations are. But I foresee basically things continuing with therapy, Dad gradually having increased parenting time, assuming that goes well, and assuming the kids and Dad make further progress in therapy, that we could get to a point where there's some parenting time at home with Dad, eventually. Thank you.
All right, Ms. Cooper, in the report from the therapist, it mentioned the family discussing the desire of adding Bentley to the family sessions. Have you had communications with Bentley or regarding that, whether he desires to have any contact at this point?
I have not since I got this report though, and also I hesitate because I think there's probably a valid reason to have a no contact order in place in the criminal case. So I think that matters to see what happens there. Maybe once that case is resolved, his perspective may change. I just don't think it's appropriate right now, especially given the criminal case still being pending.
Okay, they're in the criminal cases in my division, so I don't want to go into the details as Mr. Booth doesn't have his criminal attorney here, but I think it's okay just to give a status as it was announced in open court at a pretrial hearing back on April the 18th. It was announced that the state would consider dismissing the case if certain conditions were met by Mr. Booth, and then it was set for status on June 20th. So that's
Okay.
that's where that case stands, if that's of any use.
That's good information. Thank you, Your Honor. I couldn't tell that from looking at Odyssey. I did note that the jury trial was not, officially rescheduled, so I kind of wonder what was happening there. So yeah, I mean, if that changes, I would definitely have conversations with Bentley about that if that happens, and kind of see about potentially working through I think it should be therapeutically driven, if I was making a recommendation right now.
All right, thank you, Ms. Cooper.
Thank you.
Your Honor,
Yeah, go ahead, Mr. Booth.
if you want to tell them what the conditions of the dismissal were, I'm fine with that.
All right, I just don't want you to provide any updates on anything, Mr. Booth, especially without your criminal attorney here.
Yes, Your Honor. I just think it'd be prevalent to everybody knowing what the conditions were in this matter.
The conditions, at least as far as my docket notes reflect, is that Mr. Booth completing a parenting class, continues family therapy, and writes letter of acknowledgement. So that was what was announced on the record as reflected in the court's docket notes. And again, that the next hearing date is June 20th. All right, let me go through these motions and make sure I've got everything. I think the pending contempt issue kind of ties in, and I'm going to go through, Ms. Hoyle, your motions first as they were filed before Mr. Booth. There's a verified motion to sell the marital residence. which based on my recollection would tie into the issue that's before the court regarding the contempt. Is that accurate?
That is accurate. We're waiving the contempt, but we would like to go forward on the verified motion to sell the marital residence.
Okay, then you filed a motion to establish child support and a
Yes,
motion to settle order on the motion to compel. Were there any other motions that you filed that are currently before the court?
not before the court, Your Honor.
Okay, and Mr. Booth, I have before me a motion for a protective order. That's regarding the information regarding the VA benefits, a motion to reinstate original parenting plan, and a motion to deny request for temporary child support and spousal maintenance. Are those the three motions that you filed?
Yes, Your Honor.
All right. Well, I want to address the temporary parenting plan. Because Ms. Cooper, I think for your purposes, I don't think I guess whether the court what the court does with the marital residence may have some impact on visitations and so forth, but I don't think the child support issue is necessarily in the purview of the guardian ad litem. I don't want you to have to stay on here endlessly. So what would be your recommendation at this point regarding some increased parenting time for Mr. Booth outside of the family therapy? Or are you prepared to make such a recommendation yet?
I don't have anything real specific, but I would hope that the parties could reach an agreement on something, expanding it, maybe an additional evening or time. Like, it is summer now, the kids' schedule is pretty wide open. I don't know if that would work with dads, but I'm hoping they can at least spend an extra couple hours a week together.
All right, I'll tell you what I'm thinking initially is I think we're at a point where we need to, I think things are going well according to these therapist updates where there needs to be some time outside of that setting to see how things go. I don't know what everybody's schedules are this summer, but what I would anticipate is, you know, some blocks of time, either on an evening or on a Saturday or a Sunday, where Mr. Booth can spend, you know, several hours for a period of time, or at least enough time to have some meaningful parenting time. I usually consider a minimum of 4 hours to be at least a minimum requirement to be able to do something meaningful with the children. At least do that initially. I still would want to see Ms. Cooper's final recommendation report before making any sort of final orders, and I want to see how the criminal case develops, because that'll certainly impact parenting time with Bentley. So again, I don't want to just issue an order because I don't know what your schedules are like. So that might be a time, knowing what I'm anticipating, perhaps Mr. Booth and Ms. Hoyle can suggest some times when they're available, and we can establish that now. Do you need
I think we can do,
Do you
I
want
don't
to visit with your client, Ms. Hoyle, to see if she has any suggestions on when the best times to do that might be on a temporary
yes, I would need
basis?
that.
Okay. We can allow you to go into a breakout room to do that if you wish. And let's take a brief recess while they're in that breakout room.
Judge, schedule wise, during the week, the kids have it.
All right, let's wait and go back on the record, Ms. Hoyle.
Sorry.
Ms. Cooper, are you still on here?
Yes, I'm here, Your Honor.
Okay, all right, we're back on the record, same appearances as before. Go ahead, Ms. Hoyle.
Right now, the kids are in activities Monday through Thursday until 3 p.m., which doesn't give us a lot of time because it would take an hour to transport either way. And it might be better to use either a Friday, Saturday, or Sunday for a 4-hour block of time. And we're okay with either any one of those days, just knowing the block of time ahead of time.
All right, remind me where your client is living in Cowley County or Winfield?
Yes, in Winfield.
And Mr. Booth, you're still in the Douglas area?
Yes, Your Honor. It's only a 30-minute drive between the two of us.
All right, well, I'm just for starting purposes, is there a time period on Friday, Saturday, or Sunday of a 4-hour window that would be work for your schedule for some parenting time?
Yes, Your Honor. I do want to emphasize, though, that the kids have asked for overnights to stay here and that type of visitation, not just 4-hour days or wanting.
I understand. I'm just talking about a minimum of 4 hours at this time. I'm not ready to consider overnights based on where we're at. I want to see how these initial visits go before we move in that direction.
Yes, Your Honor.
So,
And then my other question would be, would these be supervised still, or would they be unsupervised?
I'm not going to require that they be supervised at this point. These would be unsupervised visits.
Okay, Your Honor. Then any Friday, Saturday, or Sundays, good with my schedule.
All right, I'm going to make as a temporary order that all of the children, and of course Bentley is excluded at this point because of the no contact order through the criminal case. All right, I'm going to, this Friday, which would be June the 6th, starting at 1:00 p.m. to 6:00 p.m. The children will have parenting time with Mr. Booth. And that can occur. I don't want you to leave the state with them or anything like that. You all can have that parenting time at your residence, or you go out wherever, Wichita or wherever you go, can exercise that parenting time unsupervised. I would anticipate that the children be fed prior to the visits. And then, Mr. Booth, I would expect you to feed them dinner. And if you all make some modifications to that by agreement, that's certainly allowable. Now, I'm trying to remember in the criminal case if there's what our no contact restrictions are regarding Mr. and Mrs. Booth. I think is it just communication for the purposes of the parenting time?
Your Honor,
Yes,
in the criminal case, it was established that everything would be handled through the domestic case for any form of communication with Miss Booth or the children.
Are you all using an app?
Yes,
they
Your
are,
Honor.
Your Honor.
Okay, the communication regarding these visits will continue to be through the app. I guess I'm a little more concerned with the transportation back and forth, and there's going to be some obvious contact that will have to occur at these exchanges. But Ms. Hoyle, do you have any suggestions on
If exchanges occur at maybe a quick trip or something like that, that's somewhere in between, I think that would be the most appropriate.
All right,
I'm
well,
not exactly sure the
there's
best location.
there's the Casey's in Douglas, which is right on the highway. Or down in Winfield. Isn't there a restaurant in like the old train depot? Right
Yes,
there,
Your Honor.
the northern part of town. Perhaps that would be a exchange location. Thoughts, Mr. Booth?
Your Honor, that's fine. There is also halfway or about roughly halfway, there is a,
Rock Cafe?
yeah, the Rock Cafe or Route 66 Cafe, whatever the name of it is now. Or Route 77.
Well, that's probably not a bad location. That Ms. Hoyle, do you want to visit with your client about that being an exchange point? Each party drives to Rock for the exchanges.
I can visit with her about it. I don't think that, finding a halfway location is not a bad idea.
Okay. If you think you need to, if we don't.
I don't think so. I think
Okay.
I think just having a location that they can exchange at would be.
I know Rock's not exactly a metropolis, but it is a restaurant that I'm pretty sure is open at those times. But
Okay.
all right, so that'll be the exchange location. Mr. Booth, obviously, I don't want any discussion about the case, and this applies to Miss Booth as well. But I know you haven't had unsupervised visits, so I don't want any discussion about the case, about the parenting plan, about what's going to happen in the future. I don't want the kids to be exposed to any of that kind of talk. Your visit should be just spending time with them, reestablishing appropriate activities with them. I don't want them to be involved in where they might go or what might happen with this case. Is that understood?
Yes, Your Honor.
All right, and I want to do,
Your Honor, I do have one other question.
go ahead.
So currently Harley is in a PRTF in Salina, Kansas. Per the temporary orders that were established, I haven't been able to have any visitation with him because it would be supervised for 2 hours on Saturday mornings. With this, is there any way I can have that exemption that if any child is in the hospital that I can do a visit with them while they're in medical care?
Is Harley still hospitalized?
Yes, Your
Yes,
Honor.
Your Honor.
All right, so he wouldn't be able to participate in the Friday visits?
Not at this
Correct.
time. I think that they do establish, so for parents to be able to come up and visit and have some sort of visitation, I think that we may need to, if my understanding of what Mr. Booth is saying is that with the current order, he wasn't able to go and visit because the order established specified parenting time. But I think if we unspecify the exact time where he's to be allowed a certain amount of time during the week up there, then he would be able to visit with Harley separately. I don't necessarily think that's, it's kind of up to the facility realistically of how they handle that. But I do know that they allow parent visits.
All right, Ms. Cooper, do you have any thoughts on Mr. Booth having visits with Harley?
I would hope that we could put language in the temporary order that allows that, or that the PRTF is comfortable with allowing it based on that language. And I think what Mr. Booth suggested is probably appropriate.
Okay, well, I agree. I think Mr. Booth should be able to have some contact if the facility allows it. And as long as Harley's receptive to it, I'm not sure what his overall condition is, but I don't want the visits to be detrimental to him, of course, not knowing what all's going on with him. But perhaps visitations with Mr. Booth would be helpful. I just don't know at this point. So, need any further direction on that, council, as far as putting it in an order?
I don't think so. I think if we just leave it kind of open-ended, that hopefully that'll allow the facility to figure out if it's appropriate or not. I think that because they are therapists dealing with his particular behaviors, that, I mean, I know that they do allow visitation. I don't know how much it's going to be receptive for the visitation, but I think that should be able to leave that open if I allow the facility to determine if it's appropriate in the order.
All right, I think that would be fine.
Okay.
And then I want to establish, I want these visits to occur every Friday with these same what I'm wanting to do is set a hearing date, because by then we'll have a better idea of how these unsupervised visits are going. Hopefully, Ms. Cooper, you'll have produced your recommendations, and when we come back, hopefully there'll be a resolution on the criminal case, and then the court would be in a much better position to issue more permanent orders regarding the parenting time. But this at least keeps us moving forward in that regard. Angela, when would we be looking at? I want to allow at least 30 days for this to occur. Ms. Cooper, when do you think you'll be able to have your recommendations done?
Well, I would like to see some of these Fridays, happen, have some progress in therapy. So I think 30 days or so would be appropriate. And then I could have, if we have a court date for review, I would be able to have my report in about a week ahead of time.
Okay.
Judge, I have July 17th.
How much time do we have?
I have the whole day.
I'm sorry, I'm not available on July 17th.
How much time do you think we would need, Judge?
Well, I want to allow time if we have other issues regarding these motions that need to be set over for evidence, that we can just hopefully take up everything. Again, I'm going to try to address some of this stuff today, but
I
At
have
least-
July. Oops, sorry, Judge.
I was going to say at least a half morning or a morning or an afternoon.
I have July 10th at 9 o'clock.
I'm sorry, I'm not available from the 9th through the 17th.
That puts us into August. August 6th. I'm sorry, August 5th at 9 o'clock.
I have a 9 o'clock that should only last about 15 minutes at the most, so I could do just after 9.
9:30.
Sure.
That works for me. The 5th, August 5th.
And let's, Angela, that's a duty day?
Yes.
All right. Okay, and let's block some time out, maybe till 2 in case we need extra time.
Yes, Judge.
All right, and I think I'll make that in person.
Okay, Judge, I'm sorry, that changes things for me. My 9 o'clock is in person in Harvey County, so I would need
Okay.
some time to get to Butler County.
What if we did it blocked off? Angela, can we block off that afternoon?
Yes, Judge. We could do 1:15 to 5.
Does that work better?
That works for me.
Does that, Ms. Hoyle, does that work for you?
That does. I
And
can make
Mr.
that work.
Booth?
Yes, Your Honor.
All right, so these Friday visits will continue. Now, I noticed 4th of July is on a Friday. Ms. Booth, do you already have plans for 4th of July?
No, Your Honor.
Any objection to Mr. Booth having the regular scheduled visits on 4th of July from 1 to 6?
No, Your Honor.
Okay. All right, well, the order will be that these visits from 1 to 6 occur every Friday until this hearing on August the 5th. And then the therapy will continue during this time. And Ms. Cooper, perhaps if you could let's set a deadline, maybe to have the GAL report. How much time do you think you would need? You'll probably want to visit with the kids after these visits have gone for a few weeks. Maybe
Right, so,
maybe by July 25th.
okay.
Does that give you plenty of time to do what you need to do?
Yeah, that looks good.
And
I
then
can do
that
that.
would give the parties some time to digest the GAL report before that August 5th hearing. Any comment, Ms. Hoyle
No, I think that's appropriate.
and Mr. Booth?
That's fine, Your Honor. What was the date for the JL report?
By the 25th, July 25th by 5 o'clock.
Yes, Your Honor.
All right, any other issues regarding these temporary parenting time orders we need to address from your perspective, Ms. Hoyle?
Not with regards to the visitation and parenting time, Your Honor.
All right, and Mr. Booth?
Not this time, Your Honor. Let me double check my motion to see if there was anything else in there.
Oh, Your Honor, I did forget. Can we have them, if they're gonna change the times of any visitation by agreement, to communicate with each other prior to telling the children that they want to change the times? So that the kids don't get excited about something and then mom's like, no, we're doing this.
Yeah, I think that's appropriate.
Okay.
Mr. Booth, any comment?
Your Honor, with that, the children have brought up in family therapy, and they're the ones that have requested the times, and I tell them constantly that they got to talk to their mom about it. So
Yeah.
that's where some of that's coming from.
Communicate any of the changes that are made by agreement through the app, so there's a record of everything. And if there's an issue, emergencies happen, I understand, but if either one of the parents needs to make a change to the schedule, please try to provide adequate notice. to the other party so we don't run into any issues.
Yes, Your Honor.
All right, anything else regarding the temporary parenting orders? All right, Ms. Cooper, did you have anything else to add?
No, I think that covers everything.
Okay, now as far as these other issues, Ms. Cooper, I don't know if it would be necessary for you to remain on here. You're welcome to if you wish. Ms. Hoyle, do you feel that Ms. Cooper's presence is necessary as we work through some of these other issues?
Not for the other issues. Do we need to set this for a pretrial at some point?
Well, where are we at on the property stuff? I mean, I guess that's still, the house will have a lot to do with that probably. So.
Yeah, sure.
Are you wanting to go ahead and set a trial date?
Yes, I'd like to be able to, the issue is that we've been kind of dancing around with the property issues, and I'd like to have a date that we need to settle these by, is essentially what I'm looking for.
Well, how far out are you suggesting past this August 5th date that we have?
I'm thinking maybe October. I think that gives us plenty of time from August 5th. I mean, maybe September. I'm not sure that we need to go too far out.
All right, Mr. Booth, any thoughts, suggestions in that regard?
No, Your Honor.
Okay, well, we can go ahead and set a trial date, and then I just would use that August 5th date as a pretrial, see where we're at on all the issues at that time. I'm hopeful or hoping that you all will, as we progress, perhaps come to some agreements on this, but if not, we'll go ahead and have a date on the calendar to resolve them. Angela, do we have a full day in September or October?
Yes, Judge, I have September 16th at 9 o'clock.
Does that date work for everyone?
Yes, Your Honor.
Yes, Your Honor.
All right, and that'll
So-
be go ahead, Ms. Cooper.
I don't know how much of it would involve me. I have a couple of hearings scheduled that day, but I could be available for part of the day.
Okay. Well, again, if there's any parenting time issues that are gonna be in dispute still, obviously you need to be present for that. What time are your hearings?
So I have an 11 o'clock, it's on Zoom, it's in Butler County on Zoom. It should not take long at all, probably 10 or 15 minutes. I have a 1:30 that I could get coverage on in Sedgwick County, so I could maybe just need a break at 11 instead of worrying about the other one.
In that case, I think if we could put you at if you're gonna need to testify, you could testify first. And then if we still need you after 11, could come back after lunch perhaps, or a different time.
Okay. Okay.
All right, then that'll be an in-person all day. We'll just set that as the trial date. We'll use that August 5th for pretrial.
Your Honor, I have one more question about the visitation temporary order.
Go ahead.
Is there any way that, since it is 60 days before we have that August 5th hearing, Is there any way that we could put into the temporary order that once the termination of the criminal case or the outcome of the criminal case that we can bring Bentley in for family therapy with me and the other children at a minimum?
Ms. Hoyle, your thoughts?
I think that we could, I don't want to necessarily put that in there that if it resolves, I would suggest probably putting in that we could have a discussion, we can contact and we can do maybe an agreed order with the input of Miss Cooper on that. Because I would think that she'd want to talk to Bentley prior to adding him to the family therapy.
I agree, and I think Miss Cooper, if you could have a discussion with Bentley to provide some feedback, I think it would be appropriate if Bentley's receptive to it, if the therapist is receptive to it, that go ahead and start happening. But obviously, that's going to depend on what happens in the criminal case, because as of now, that no contact order still remains until the criminal case gets resolved. So
Right, and I'm happy to address that in the event that it's dismissed or that no contact order is lifted and that there's a recommendation for therapy. I think that's potentially appropriate at that point.
okay. Ms. Hoyle, does that help you in crafting some language in the order?
Yes, I think that could be helpful and we could address it kind of like as an agreed change of the order if we need to. I don't think that that's what I don't want to do is put in something that just triggers based on one event without having the input of the ad litem in there. So I think we could probably put, if we all agree that this can occur at this event, then maybe I can craft something that works.
Sounds good to me.
I think that's a good way to do it. All
Thank you,
right.
Your Honor.
Any other issues while Miss Cooper is still present, Miss Hoyle?
I don't think any other issues that don't deal directly with either child support or property
All
are
right, and
left.
Mr. Booth?
The only other request or the only other thing is in family therapy, we're kind of we've kind of hit a wall because we can't talk about certain things. Like we can't talk about any of the past, or we can't talk about like how the divorce, like how they're dealing with the divorce, stuff like that. So there is a little bit of a barrier there. So I don't know how anybody wants to address that, or if we want to wait and address it later.
Well, I kind of leave those issues to the therapist. I mean, if the therapist feels it's beneficial for the children to work through some of those issues, I think that's probably appropriate. What I don't want the parents doing is influencing the kids outside of that setting by saying this is what is going to happen or what should happen, or mom or parents criticizing one another. That's what I don't want to happen. If the therapist thinks the kids need to work through some of those issues in therapy in that setting, I'll leave that to their discretion.
Yes, Your Honor. The way that the temporary order was currently worded, she didn't want to cross that boundary because it said that I wasn't allowed to have any of those communications or be a part of those communications. So if we could have it worded that it can occur in therapy, that would help her out. And that was her request.
Ms. Hoyle, your thoughts?
I can probably try and word it that therapeutic discussions can include, if deemed necessary by the therapist. I guess I could word it in some way that allows, if the therapist thinks that discussing it with Mr. Booth in therapy I think that that would be appropriate. And same thing with Mrs. Booth with her therapy, with family therapy with the kids. She's attending that as well. So,
Yeah, I definitely would want it to include both the parents.
okay.
Okay. Ms. Cooper, do you agree?
That sounds good to me. Yes, Your Honor.
Okay. All right, Ms. Cooper, I think you can probably exit the meeting at this point. Appreciate your input and your work on the case thus far.
Thank you.
All right, have a good day.
You too. Thank you.
All right, the first thing I want to address is the child support issue. Ms. Hoyle, have you had an opportunity to review Mr. Booth's motion and the law and cases that he cites?
I have, Your Honor, and which particular motion? He has two of them that kind of address both of those issues, or address the issue. In his motion for protective order, he's talking specifically about his disability compensation. And I've had a chance to review that, and the statutes that he's bringing up. The only thing is in Rose versus Rose, which is a
Ms. Hoyle, I don't want to
Okay.
get into the merits of it just yet.
okay.
I just wanted to make sure that it sounds like you've looked at those and are familiar with them. It's not an issue that I've seen very often. I did read through the motion. I haven't had an opportunity to go through any of the cases or the applicable law. But let's go ahead and address that, because I think the motion for protective order that's been on file affects whether or not we move on to the other motion. So, Mr. Booth, I'm gonna let you argue your motion for protective order at this time. Are you prepared to address this issue, Ms. Hoyle?
Yes, Your Honor.
And I think this kind of ties in with the motion to settle the previous journal entry, does it not?
It does.
Okay. All right, go ahead, Mr. Booth.
Yes, Your Honor, I've requested a motion for a protective order. I do believe that the motion covers everything. Per federal law, any VA compensation is protected from disclosure. Additionally, the only thing I am obligated to report per federal law is how much I receive per month for child support calculation purposes. It also specifies that it cannot be used for alimony calculations or any of that.
What specific federal law are you referencing, Mr. Booth?
Let me look it up. It is 38 U.S. Code 5301, Section A1.
And your argument is that prevents you from being compelled to produce any information regarding your federal or veteran's disability other than the monthly amount?
Yes, Your Honor. As well as in the state of Kansas, there is Bar 29 Can App Appendix 2D 846 in 2001, where the state of Kansas upheld the same ruling. As well with that, none of my VA disability, it is all for pre-marriage and the claim wasn't filed until after legal separation. And additionally, none of the money has been used towards anything that was commingled or co-mixed between me and Miss Booth. It has all been everything from after.
Okay, anything else? Because my understanding of it is that the court can consider the veterans disability income to establish the overall income. I think what's unclear is what the court's authority is to garnish those monies or enforce any order that's made. But I have not done a deep dive into it. Ms. Hoyle, your response?
Your Honor, I have done a deep dive into this. This is a question that pops up regularly for me as in this legal practice, but for income purposes, the disability compensation is considered income for purposes of determining the child support. It can also be determined for spousal maintenance, but we cannot garnish it, assign it, or in any way force him to assign an amount to Mrs. Booth. So what that doesn't necessarily mean that you can't order child support based off of that number. In Rose versus Rose, which is 481 US 619 1987, and this is regularly used in determining that for purposes of child support, this is considered income.
What's that case citation again?
It's 481 US 619
In what year was that published?
1987.
All right, go ahead.
And we're not asking for the numbers with regards to his lump sum and the amount for disability payments for anything other than the purpose of determining income for child support purposes. We're not asking to even divide it or separate it out as marital property. We're solely asking, we want to make sure that we have the correct numbers and what he's received in this to determine what was the amount that he makes so that we can determine his income for purposes of child support. Now, we've included what we think to be the correct number based on what he has stated. But when he's talking about disclosures, the statutes that he cites, actually, the disclosure is the disability of the veteran, which is not something I've asked. I didn't ask what he was disabled with. I didn't ask for his service records. I didn't ask for any of that, which is protected. But I'm asking for the numbers so that we can determine his income for child support purposes. And that's what he's denying us by using this. And I think he's misinterpreting the law when he's stating that this is not disclosable purposes.
So your request is simply to know what our confirmation of the monthly amount he receives in veteran disability payments?
Correct. And the reason why we want the lump sum is because it determines how long he would have been receiving that and for what time period.
Right, so there's a lump sum and a monthly?
What?
Okay.
So can I explain this a little bit because I do know quite a bit about it?
Please
When
do.
a veteran files initially, they file an intent to file. And so when they're filing for their disability compensation, which is their service-related disability, they are filing for this. So they send in their intent to file. That is like the trigger date for when the veterans when the VA determines as the initial date of payment. So it usually takes several months, and I want to say it can take up to a good 6 to 9 months before they make a determination on the disability rating and whether or not it's service connected for the benefits to kick in. And then based on that rating, they give a specific number, and based on how many dependents that the veteran claims, they give a separate number for those dependents. So Mr. Booth, having 6 children, would receive an amount. I think he receives a certain amount as a veteran with a dependent child. And then for each additional child that he claims with the veteran, he would receive another amount in addition to that first amount. So from the time he filed to the time he receives his initial first payment from the VA, there is a lump sum that dates back to that original date that he's filed the intent to file. So it shows kind of a time period in which he would have been receiving this money, even though he received that one lump sum payment. Then every month they receive an additional payment. And that is their income payment or disability compensation payment that is based off of the VA's rating and the number of dependents that he's claiming.
All right, so as I understand it, the court can use that information to establish an income amount. However, the court has no ability to enforce payments if that's a person's only income. Is that accurate?
They have no way to garnish the payments. You can order it, they are required to follow a court order. So if you were to order based off of their payment, if that was his sole income, that is income for purposes of determining child support. He would be required by the court to pay that amount. Now, you can't go in and go say, well, I need to garnish this amount. So what that means is the VA will not take out a portion and send it to the Kansas Payment Center. That has to be done by the veteran himself. They can, with the veteran's permission, but it has to be through the permission of the veteran can assign that portion of his disability to go to the Kansas Payment Center for child support purposes. But he would have to do that on his own. It has to be an action that he does to meet the court order for child support.
All right, thank you, Ms. Hoyle. Mr. Booth, I'll allow you to make any response.
Yes, Your Honor. Ms. Hoyle stated a case law from 1987. I'd like to bring up that there is more previous case law that has preceded that. There was one in 1989, which was Mansell, which the U.S. Supreme Court made a ruling where my VA compensation is not considered divisible like any marital property, as well, and how versus how.
I don't think it's being requested to divide as a marital asset. I think it's being requested, which the law allows, is to establish income for establishing a child support order.
Yes, Your Honor. However, my thing is they're trying to backdate child support from when, we first separated.
Which the court has the ability to do.
Correct. However, there was not any of this money that was at that time. And that's what is that's the information that is protected from disclosure of when all this.
Why is it protected? You all were still married.
Yes, Your Honor, but because we were legally separated, it is not considered disclosed.
There was no order of legal separation. To my
Your
knowledge.
Honor, per the way the VA and the federal government looks at it, is the moment that a divorce was filed, that information is no longer relevant, especially when did absolutely nothing to pay for any of her bills. If the
It's
money at
still
any time
considered
during marriage is
income during the
covered.
marriage, Mr. Booth.
What, Your Honor?
It's still considered income during the course of the marriage.
Well, if that's the case, Your Honor, then Miss Booth, all the money that she's made should be helping to pay for marital debt, which has not occurred.
Well, those are issues that are yet to be resolved. The parties should be meeting their financial expectations, or obligations, but I'm gonna, well, the request for a protective order in regards to the amounts that are being paid each month and the lump sum, I don't find to be protected, and those are to be disclosed. And I'm talking only the amounts, not any of the details regarding the disability, not any medical records regarding the disability, simply the amounts, the lump sum payments and the monthly payments. And I believe I've already ordered that those be provided. And I think that's part of an issue that is before the court on the motion to settle the journal entry.
Yes, Your Honor, and I strongly object. I would request that before you make a ruling that you review all the cases and everything that are put into the motion.
I have made my ruling, and that is my ruling, Mr. Booth.
All right, Your Honor.
So I think I'm not going to order any particular amount at this time because I don't think we have all the documentation needed to prepare a child support order. Obviously, the court can go back to the time of filing when making child support orders. But at this time, I don't think there's enough information before the court to issue an order.
Yes, Your Honor. While we're on that topic, with Ms. Hoyle's motion to establish child support and the child support worksheet, I strongly request that you order proof of income for Ms. Booth, as well as to include the $2,000 in adoption subsidy into considered income, as well as documentation from pay stubs. Because
Both parties are ordered to provide any proof of income to the other party. So that is an order.
Correct, Your Honor. According to the child support worksheet, Ms. Booth states that she only made $12,000 last year, and the court already established that she gets $2,000 in adoption subsidy, which would be a minimum of $24,000 a year.
Your Honor, the adoption subsidy is not considered income. It can be income for the child, and we can put that in the child support as a disability income for the child, but that's about the extent of where I can put that. It's not considered income of the parent.
Yeah, well, that's an issue that will have to be, if you all can't get it resolved prior to trial, that's going to be an issue that we'll have to argue about it at trial. 'Cause I'm not issuing or approving any worksheet at this time, as we don't have all of the relevant information. Both parties are ordered to provide all documentation that proves income to the other party. Mr. Booth, you're welcome to provide a proposed worksheet at some point if you wish. But that's the order now is for both parties to provide the documentation that's been ordered. And then I'm going to make that order that's to be provided within 30 days.
Yeah, sure, and I'll make sure that I have her pay stubs to Mr. Booth within 30 days.
And then if you both want to submit proposed worksheets, once you have all of that, you each have all of that information, I would encourage that.
Yes, Your Honor.
And then if the issue's not resolved, it can be teed up for trial.
Yes, Your Honor.
All right, let's address the marital residence issues. This is a carryover from the contempt motion. Ms. Hoyle, I'll allow you to argue your motion to sell the marital residence at this
Yeah.
time.
Your Honor.
Yes, Mr. Booth.
Also in the protective order, it was requesting to protect information, such as, let me find it. That way I can give you the exact paragraph that it was in. I also requested to protect from inquiry into DCF investigations, alcohol use, as there has been Ms. Hoyle and Ms. Booth, neither one have established that there has ever been any concerns in regards to alcohol use with the children or any form of like further inquiries into DCF. I mean, Ms. Booth's been filing DCF reports against me this entire time.
I guess I don't understand the issue. Is this a discovery issue?
No, so like, for example, Ms. Booth has continued filing DCF accusations against me, saying that I've been abusing the children during supervised visits. So the
There haven't
court
been
documents,
supervised visits other than the therapist appointments.
yeah, between the therapist appointments and the supervised visits that have been occurring on Saturdays, Ms. Booth has been accusing me through DCF by filing reports saying that I'm abusing the children during these visits.
Ms. Hoyle, what your response?
Your Honor, I don't know where Mr. Booth is getting that she's filing these reports. If he's been investigated by DCF, it's not, I don't think there's any proof or anything other than his words stating that he believes it to be my client that's initiating these reports at this time. So I don't think that in his protective order, he doesn't actually list it in his protective order. I've read that over. There's nothing in there about protecting from any DCF reports that have come in. And I believe that was one of the questions that was in the interrogatory that we requested be answered.
Well, I can't order DCF not to investigate something. That's not within the court's purview. If they feel they need to investigate something, they can, and then the court will address that if something comes out of an investigation. But I can't order DCF not to investigate.
Correct, Your Honor. I'm not asking you to say that DCF can't investigate. I'm asking you to put an order that Ms. Booth can't sit here and make false accusations to DCF to try and get the outcome, to the point that I was accused of abusing physical abuse of Bentley during a visitation in March, and I haven't had any contact with Bentley in over a year.
I hope there are not unfounded accusations being made just to cause a stir. If there are legitimate concerns, obviously those need to be addressed, but I'm not going to order somebody not to report something they believe may reasonably be occurring. Obviously, it'd be discouraged not to make false reports, as that will something the court will take into consideration in any further orders. So hopefully that's not being done, and That's how I'll address that, Mr. Booth.
Correct, Your Honor. And just for the record, it is paragraph 8 of the protection order that is addressed.
Yes, I just saw that. All right, let's address the motion to sell the marital residence.
Your Honor, at this time, we filed a motion to sell the marital residence. This residence was purchased in 2020 at the time both parties were married. This is essentially the only asset within the marriage, and both petitioner and respondent lived in this marital residence up until March of 2024, at which time they were separated, and petitioner has since been in possession of that residence. The temporary order did indicate that Mr. Booth was to be responsible for any and all bills associated with the marital residence. And recently, as of January of this year, the respondent was served with a foreclosure notice on that marital residence. We do not have any indication that that has been caught up, other than Mr. Booth indicating at the last hearing that he has since caught it up, but we don't have any documentation. We have reached out to the foreclosure attorneys to determine if that's still in the process. The respondent does not want the marital residence, and we believe that as an asset of the marriage that it needs to be sold and distributed. Any equity that would be found in that home to be distributed equally amongst the parties.
All right, Mr. Booth, your response?
Yeah, sure. To first address the foreclosure notice, that is a Butler County case. It is due to the income taxes that were marital asset or debt from 2022 that has not been taken care of, and that was the initiation of the foreclosure. That case has been put on hold by the federal government, and they were stated to gather more information. So that case has been put on complete hold. As for taking care of the bills,
Do you have the case number on that?
not off the top of my head, Your Honor. I do know that it was in front of Judge Satterfield. But everything for the foreclosure has been put on hold, as the marital debt is what triggered it, and that's why it was put on hold until resolution of the marital division. As far as who's going to be responsible for this federal tax debt. Also with this, the home has been under a forbearance program, and that is also part of everything going on. So there can be no foreclosures, there can be none of that. That's why the federal government put them on hold and told them that they couldn't do anything about it yet.
Do you have documentation verifying all of this, Mr. Booth?
Yes, Your Honor. I did receive from, I don't have it with me. I can scan it and send it to the court and Ms. Hoyle, because it didn't pertain to this case until now. But I do have the forbearance. I do have that at some point Ms. Booth's name was added to the deed after separation. And then I also have I have the forbearance stuff, the showing that Ms. Booth somehow had her name added to the deed, as well as having that this case has been put on hold by the federal government, and that it was initially triggered by the federal income tax return.
Are you current on the mortgage payments?
Yes, Your Honor, I am. Through the forbearance program, I am.
Have there been hearings in front of Judge Satterfield on that case?
No, Your Honor, because when the foreclosure company initially set everything up, they had to go through the Department of HUD, and they had to request a whole bunch of other things, but it was initially triggered because of the federal taxes. And they're the ones that said, no, you guys can't do anything. He's in a forbearance program. And So, and the tax debt that you guys are inquiring about and initiating this, you basically is set up in a divorce matter. And so Judge Satterfield put everything on hold until
Through a
everything's done.
journal entry? If there haven't been any hearings,
Nope, there was no journal entry. This was literally just letter that I got stating that everything was
and you
put
have
on
a
hold.
copy of this
And then
letter?
contacting the mortgage company, and they told me that they got told to put everything on hold.
Do you have a letter from the Butler County District Court saying that the case has been put on hold?
No, Your Honor. I had a letter from the mortgage company telling me that.
All right, Ms. Hoyle?
Your Honor, we've never received any such notification of a forbearance of it. I don't know what he's talking about with regards to Ms. Booth's name being on the deed. She is listed as a party to the Butler County suit for foreclosure, and I can give you the case number in that.
If you could,
It's 25 CV 000033. And it is Butler County.
I'm gonna take a brief recess and I'm gonna pull that case up. So I have a better idea of what's going on with it.
Yes, Your Honor.
All right, we're in recess. Don't leave. I'll be hopefully back here soon. All right, we'll go back on the record, same appearances as before. All right, I was able to access the mortgage foreclosure action, which is the 25 CV 33. There's actually another case, Mr. Booth, that you're referring to as the tax warrant case. That's 24 ST 001017, which is for individual income tax from 2023. Both cases are, at least according to Odyssey, still pending. There don't appear to be hearing dates set, or there's no docket notes that exist, but I believe there's still they haven't been resolved or dismissed, so that they're still pending actions at this point. So I haven't had time to read through everything, but I just wanted to see what was out there. So those two cases are still ongoing, but your position is that you're updated on the mortgage payments and paid any back monies due in regards to the mortgage?
No, Your Honor. Due to the forbearance program, the way it works is it does incur a debt that will be distributed after any sort of whatever caused the forbearance to start. So in this case, it was due to my suspension from work and the ongoing legal matters. So until I go back to work, that money will then, when I return to work, that money will then be distributed and change the monthly payments on the house. So it's an incurred debt, but once everything's reset, then it will just be redistributed into the mortgage.
Are you making a monthly mortgage payment?
Yes, Your Honor, I am.
And how long have you been doing so?
The entire time that I've been in the residence.
So how come, where's the debt coming from then?
So, Your Honor, part of the forbearance program is if you miss a payment or if it's late, they withdraw you from the forbearance program and then I have to reapply. There was a payment that was late and they pulled the forbearance program and then incurred all the debt that had been previously established. And I had to reapply for the forbearance program and that debt went back into that.
Is your intent to stay in this residence?
Yes, Your Honor, it is.
All right,
especially if I'm going to have visits with the kids and the kids are going to need a place. I need a residence for where the kids can stay and be comfortable and feel at home.
all right. Ms. Hoyle, your response?
Your Honor, this is a marital asset, and I would like to see. I don't think that either party can really pay the mortgage and pay the bills on this residence to keep this residence as a residence for either party. And I think that this being in a foreclosure proceeding, having all the marital debt between both parties, that this is essentially the only way in which to divide up this in a reasonable manner that would be equitable for both parties would be to sell this property.
All right.
Your Honor,
Go
Your
ahead.
Honor, that if we just establish that the money and everything is unknown as to even to do child support calculations, how can Ms. Hoyle sit here and say that neither one of us can reasonably afford residence?
Your Honor, he's stating that his only income is this disability, and he's also stating that so either he has enough to pay child support calculations or doesn't have enough to pay the mortgage. At this point, he's not showing in any manner. He's actually filed a motion to not have any child support calculations because he apparently makes no money.
All right, Mr. Booth, these documents that you are saying you have, this forbearance program, do you have the ability to email those to Ms. Hoyle and to the court?
Right this second, no, I would have to go in and I would have to scan them and everything. They're like physical hard copies.
How many pages is it?
I don't recall. I think all in all, I think it's like 10 pages.
Well,
There might be more.
I think at this point, I need some more information before making a decision on whether to sell the marital residence. I want to know the party's income. I think these need to figure out what's going on with these two cases, the tax warrant case, the foreclosure case. The court needs to review these forbearance documents Mr. Booth has discussed here on the record. Obviously, if the foreclosure case comes to a point where this court needs to act before I've had an opportunity to review all of this information, it can be brought by way of an emergency motion. But at least from what I can tell from the court system, there are no hearing dates set on either one of those cases at this point. Why that is, I don't know. I haven't had enough time to look at them. So I'm going to table this issue, but I'm going to ask Mr. Booth if you can provide that information through an email to both Ms. Hoyle and to the court. Get those documents. I'll look over these, and I think I'll just keep everything set over to this August hearing date. If action needs to be taken prior to then, like I said, an emergency motion can be filed.
Yeah, sure.
All right. Are there other issues in the motion to settle the order on motion to compel that we need to address, or has the court addressed those, Ms. Hoyle?
I believe the court's addressed all of the motions. The court, what we put in our order on the motion to compel is what we believe the court ordered. I have seen no other objections other than Mr. Booth's wanting to reassert his the protective order for certain information, which he's already done.
All right, anything else, Mr. Booth, you say in that regard?
Your Honor, on the motion to compel, I just want to reiterate that in the protection order, it did request to protect the DCF investigation inquiries. Also, I have, just to update the court, I have been trying to get any past arrest documentation to show distal. The attorney that worked that case has been contacted and he can't even get it from the court. So we have tried. So at this point, I request that that be considered burdensome to try and obtain those
I don't
documents.
know what you're referring to, Mr. Booth.
So in the interrogatories, there was a requesting any previous arrest documentation. There was a dismissal from 2007, and neither the court nor my attorney at the time have that documentation, and we have both tried finding it.
Your Honor, my request in their interrogatories is a written request. All it would entail would be for him to give a recollection of any time that he's been arrested. And I think that that was sufficient information if he has an arrest to disclose that arrest and around the time and that sort of information. I can't recall exactly what the specifics of the interrogatory are at the top of my head.
Correct. However, Your Honor, you requested if I had anything showing that it was dismissed, expunged, anything like that, then I needed to provide it to the court.
Okay, I don't recall specifically. That's not an issue that I was aware that was currently before the court. If you can't get it, you can't get it, or you can, if you need to file an answer or stating that you were arrested, you believe the case was dismissed, you can't find the, or aren't able to get a copy of it, then you can put that in there, I guess. I don't know. There's been no objection before the court, so I'm not going to address it right now because I don't know specifically what it is.
Okay, and then the other, I can provide the DCF document from back in May when I first got it. However, there has been, as I stated, other DCF accusations that have went through against me, which DCF completely threw out because of the no contact with Bentley and them being specific accusations towards Bentley. And so they have dismissed all those cases as unsubstantiated.
Okay.
And then the other in the protection order was the request for alcohol use and I'm requesting again that it be considered burdensome to put every date in which and how much and what was consumed for any time that alcohol was consumed.
I thought that was addressed at the last hearing.
Yes, Your Honor. However, I'm requesting that it be considered burdensome to provide every single date for the last 12 months of any time that alcohol was consumed.
Your Honor, at this time, I think Mr. Booth is asking for the court to reconsider his ruling on our order to compel, on our motion to compel. And the court has made a ruling, and what we've put in our order on the motion to compel is what the court ordered. And we're asking the court to just continue to order it.
If I ordered it, and then it needs to be part of the journal entry. I understand you may disagree with the court's order, Mr. Booth, but the journal entry is simply to reflect the orders of the court from the hearing. There's not a motion for reconsideration currently before the court, and I'm not going to reconsider it at this time. Just to settle the journal entry, if I made the order, then it goes in the journal entry.
Correct, Your Honor. And that's what I'm saying is that's what I put in the protection order that we haven't addressed.
Okay, well, that's not what you're asking. I made that order. You haven't filed a motion to reconsider the order. You filed a protective order.
Okay, so I filed the wrong motion.
Apparently.
I was going off of legal advice that I was told, so.
Well. All right. Ms. Hoyle, can you draft a journal entry that reflects the orders that the court has made today?
I can, Your Honor. Do you want one journal entry or would you like one for each motion and the status?
I think it's probably easiest to do one journal entry with one signature from each party. I think it gets your thought. What were your thoughts, Ms. Hoyle?
I was hoping to do just one journal entry with all the information because I think it all ties in together. I think there shouldn't be more than one journal entry. I think it causes more confusion.
I agree. It can be separated into various paragraphs that outline the orders.
Does the court want me to just submit the proposed order on the motion to compel?
Well, Mr. Booth, are you going to sign it?
Your Honor, if I'm being
understand
court-ordered,
I
sign the
understand
document.
your objections, but the question is, does it properly reflect the orders that the court made on that particular court hearing?
I would have to go back and read the journal entry again. I don't have it in front of me of what was put in it.
I don't
But
believe
if-
any objections have been, well, I'd submit it Rule 170.
Yes, Your Honor. And I
However, if the
submitted
court is
originally
ordering
Rule
me that,
170.
I will.
Go ahead. What was that, Mr. Booth?
I said, if the court is ordering me that I have to sign the journal entry, I
I'm
will.
not ordering you that you have to sign it. I can't do that. I'm ordering that it be sent Rule 170, which means you'll be sent a copy. If you have objections, again, not to the orders the court made, as if whether or not it properly reflects the orders that the court made. I understand your objections to them and you don't agree with them, but that's not the purpose of it.
Yes, Your Honor. And one last thing. So we didn't go into depth on my motion to deny child custody and spousal maintenance or alimony. There
There's
is
been no
a,
request made for spousal maintenance that I'm aware of this before the court, and the court addressed child support. I haven't ordered a child support amount yet. I've ordered
No.
that the parties provide proof of their income at this
yes,
point.
Your Honor. I'm just bringing up one paragraph that's in this as far as some of the marital debt that has been causing issues, such as a co-signed vehicle loan that is in Miss Booth's custody, care, that is currently in default. The state and federal back taxes that are owed of establishing who will be responsible for covering those, and any other unsecured thing that has not been established as who would pay for it or who would cover those.
Your Honor, may I respond?
Go ahead.
Your Honor, each of those things, none of these marital debts have been distributed and assigned to either party outside of the temporary order. And my understanding is that the one marital debt that does have both their names on it has not been assigned, so there's not an ability to take his name off of that debt as of yet. If Mr. Booth is more than willing to provide me a breakdown of what he deems to be a distribution of the debts and assets in this matter, I've been more than willing to go over it with him and try and come to some resolution as to the debts and assets and who would be assigned what.
Right. Again, I think those are issues that aren't right for final order at this point. those can be addressed. If you all are unable to resolve those issues prior to August 5th, we can take those up. But again, those are all, whether or not you are separated, they're considered marital debt, and they'll need to be divided one way or the other. You all need to both be making attempts to keep up on all of this stuff.
Yes, Your Honor.
All right. Anything else?
Nothing else, Your Honor.
Ms. Hoyle, can we ensure that that language is put in there, that we need to ensure that in the journal entry that we ensure that both of us are contributing to the marital debts? I do believe that the last order that addressed marital debts said that we could not pay off any of the marital debts until division.
Well, you need to pay what you've been ordered to pay through the temporary order are enforceable court orders. Generally, I'm just encouraging you both to pay your debts, just as a general principle. It'll make things easier to divide if that's being done, and to keep there from being lawsuits filed to come after you for them. So, all right. If there's nothing further, we'll be in recess. Have a good day.
All right, thank you, Your Honor.
Petitioner Stephen Booth appears in person pro se. Respondent Sarah Booth appears in person and with counsel Elaine Hoyle. Guardian ad litem Shannon Cooper also appears. We're set today for a status hearing. We were last before the court on January 6th of this year. At that time, the court expanded some supervised visits for Mr. Booth, made some orders regarding counseling for the kids, set the matter out to today for status to see how things were going. Ms. Hoyle, I'll address you first. What's the status of the case at this point from your perspective?
Your Honor, at this time, my client is not exactly happy going forward with the visitation at this point. The kids' behaviors have been escalating and becoming extreme. One child had to be taken to the crisis center, and I think 2 weeks ago. He was since released. I think that the ongoing therapy may still be helpful for the children, but at this time, we're not comfortable with the continued supervised visits. We are also a little uncomfortable with the supervision as it stands. I think that while Mr. Booth's friend, Mr. Hayes, is observing the visits, I don't necessarily know that he's in proximity to the visitation enough to be a actual supervisor. But I don't know if that's kind of where we're at right now with regards to the visitation and that.
Okay. Mr. Booth, what's the status from your perspective of the visits?
Your Honor, it's been disclosed through family therapy and through the supervised visits that Miss Booth has been telling the children certain things, such as after Harley was hospitalized, he came to family therapy and stated that his mom told him to tell me that he don't love me and doesn't want to be around me. She has also apparently been telling the kids about the divorce and about the criminal court. She has also told the children that I'm going to jail and that everything that's going on, I'm lying about. She has also apparently told the children that I hit them and I abused them and that they need to continue saying these things in order for me to go to jail. This has all been brought up in family therapy, as well as they have talked about this stuff during the supervised visits, and me and the supervisor, Mr. Hayes, have had to tell them that we can't talk about those things and that it needs to stop.
So did the therapist tell you the children said these things?
I was sitting in family therapy when they said those things.
The children said those things to the therapist?
To the therapist and me in family therapy.
Have we received a report from the therapist?
I brought this up with Miss Cooper and asked her to get with the family therapist and get a update on that stuff. I'm not sure if that's been done according to the family therapist. She still has not requested it. I did talk to the family therapist this morning. She said that if you grant permission, then she will go ahead and give me that report with that, like that session where all this was said, and get it to you directly.
Ms. Cooper,
Thank you. I would like to see an updated report from the therapist. I also need the kids to come into my office. I know there's been issues potentially with scheduling with my schedule, probably the kids' schedule, as well as mom's and the weather. But if hopefully they can get in the next couple of weeks. I know the therapist said she could get me a report within a couple of weeks.
how long have the kids been in therapy with this therapist now?
We've been going approximately 2 or 3 months, Your Honor. I think we're at like 3 months.
Right, and has any sort of a report been produced yet?
She had written a letter. I think I disseminated it back in late December, early January.
I never got that letter.
I never got that letter either.
Ms. Cooper, have you had any recent contact with the kids regarding any of these issues?
No, I need somebody to make an appointment for them to come see me at the office.
All right, well, this isn't what I was hoping we'd hear today. I'd hope we'd be making some progress, but I have concerns from both ends at this point. At the last hearing, there is some talk about the parties working out the property division. Has there been any progress on that front?
Your Honor, I've got a working spreadsheet with regards to that. I did discuss a few of the items with Mr. Booth. Some of the information was sent in interrogatories back, and I went through those, and I've got new additional questions that I'm sending out in interrogatories and finalizing that hopefully this week. I know the weather's kind of prevented me from being in the office a couple times, which that's been a little difficult, but as for getting that out, I'm hoping to have it out by Friday to him. He will get it in an email as the additional information that I'm seeking to be able to just divide it up with what we believe will be an accurate division of the property as it stands.
So you and Mr. Booth have had some communications or exchanges of information?
We have.
Okay. Mr. Booth, anything that you would add regarding the division of property and debts?
Your Honor, most of it is like I'm still trying to get a hold of the IRS for back owed taxes. They currently aren't taking phone calls or anything like that because it's tax season. Other than that, that's pretty much the big one that I'm waiting on.
And I think part of our discussion was the house and whether that be sold or not. It's my understanding that Mr. Booth does not wish to sell the house at this point.
All right. Ms. Hoyle, what's your opinion on what needs to happen moving forward to move towards resolution of not only the division of assets and debts, but issues regarding parenting time and so forth?
At this time, I'd like to get my see if we can come to an agreement about the division of assets. I think we would be really close. My only hangup is that my division of assets would include the sale of the house. It's the only realistic asset that either party has, and that would dividing that is would handle separation of the assets and debt. So I think the house does need to be sold and sold at market value. That's how I would resolve that. I believe that they've already, most of personal property has mostly been divided and separated at this point. I believe that there is very little personal property that needs to be even discussed. I think we've already handled any small items. Outside of that, the debts have already been divided as to who's going to pay what. And I think that point has already been decided. I think the only point of contention at this point is the house itself. As for the kids, I would like for my client to remain we're asking for my client to remain the sole custody of the kids, sole legal custody of all 4 children. And supervision, I think it's going to have to be what the court decides at this point. I don't necessarily know that we would come to any sort of agreement on what that would look like. My client is still not comfortable with the supervised visits as it's occurring now. And she's willing to work with the kids remaining in some sort of family therapy and then going from there at this point.
When do the children next attend a family therapy session?
Your Honor, it was today, but it was canceled due to the weather.
Okay, do you know when it'll be rescheduled?
It'll be next Wednesday.
All right, I see I received a December 23rd report from Ms. Cooper. I might take a minute to review this report. Did you send that to everybody?
I did, and I apologize. I thought I had sent that before the last hearing. I don't know if it was stuck in an outbox or what happened, but it should be out to Mr. Booth and Ms. Hoyle as well right now.
I may have reviewed it at the last hearing. I'm not sure. I don't have it, but I'm going to take just a brief recess. Ms. Hoyle, do you have a copy of that now? And
I do. I'm able to pull it up now. I did not have it one before.
Okay. And Mr. Booth, did you receive a copy also?
Yes, Your Honor.
Okay. I'm going to take a brief recess to review this if you all want to take the opportunity to do the same.
Thank you, Your Honor.
We'll go back on the record. Same appearances as before. For purposes of the record, Ms. Cooper sent to all parties a letter dated December 23rd, 2024 from Megan Howard with South Central Mental Health, giving an update on therapy. I did have an opportunity to review that. Having now done so, Mr. Booth, what's your position on what the court needs to do moving forward to move towards resolution of all issues in this case?
Your Honor, as far as with the child visitation, I would like to see more time with the children. We're doing visitations right now on Saturday mornings in Winfield or Douglas, and there frankly is nothing open at the times that work for Ms. Booth. So I would request that we have more time together. Right now we're only 2 hours on Saturday mornings. We've been doing from 9:30 to 11:30. Additionally, I would like to see that Ms. Booth stop any interactions with the children as far as interfering with the therapy sessions or the bond between me and the children, as it's already been court ordered twice for that to occur, and it's still ongoing. And then I would like to, basically, I would like everything finalized and done with as soon as possible.
Thank you, Mr. Booth. Ms. Cooper, your thoughts on, as guardian ad litem, what you'd like to see happen moving forward?
Thank you, Your Honor. I think that therapy should continue. As I stated before, the therapist has indicated she could get me a report within a couple of weeks. So I think we should keep going the way things have been going for probably for at least another couple of weeks, get that report. And then if she recommends expanding parenting time, then that's probably what I'm going to be recommending. I don't think it's, I think dad's request that mom not disparage him or talk about the case with the kids is appropriate. I don't think dad should be doing that either. I think it was already understood, or I hoped it was already understood, that neither parent should be doing that. So I think it's appropriate, if the court hasn't made that order already, to do so today.
All right, thank you,
And
Ms.
I
Cooper.
don't have any recommendations as far as the rest of their property division in that.
All right, so you don't think the therapist can get something out sooner than a couple weeks?
I don't know what her schedule is, but she told me about a couple of weeks.
All right. All right, first of all, I want to see the therapy continuing for all of the kids. I want the family therapy to continue. That appears to be of benefit to them. I have concerns with if the parties are disparaging the other parent or discussing the case with the kids. That's totally inappropriate. That's an order in any domestic case. The parents are not to disparage the other parent or discuss the details of the case with the kids. That needs to stop. If it's been happening, that goes for both parents. Oftentimes, in any case in which a parent's receiving visits or kids are receiving visits with a parent, I've seen it in sink cases, I've seen it in domestic cases. A lot of times there's some hyperactive behavior from the kids following those visits. Sometimes it's something to be concerned about. Other times it's fairly normal. I don't know what the situation is in this case. That's why I would very much like to have a updated report from the therapist. If Ms. Cooper, if I could direct you to request that, as she's apparently reached out to you to do so before, and get that provided to both Ms. Hoyle and to Mr. Booth, and a copy to the court as soon as possible. I understand.
Yes, I can do that.
I understand she's busy and probably has a backlog of cases, but if the sooner she could get that to us, the better, obviously. I'm going to keep the visitation order that's in place. I'm going to continue that. I understand your request for expanded visitation, Mr. Booth, but until I have a little bit more information, I'm not comfortable expanding that. I want to hear back from the therapist mainly, and then just get a little more time with these visits, so we can hopefully, the court will have enough information in order to make, important decisions regarding custody and parenting time. I don't want to see this case be delayed too long, but there are dynamics in this case that are different than other domestic cases, and Mr. Booth has the criminal case that's ongoing, which is now set for trial. So that's still ongoing, outcome undetermined at this point. There's information needed from the therapist. Apparently, there's still some ongoing discovery and issues going on to resolve the property division. What I want to do is set this out one more time for status, and then hopefully at that time we'll have a lot more information available. Mr. Booth, do you recall, your trial date, was that a May setting? Do you recall?
It's April 22nd through the April 24th, Your Honor.
All right, and obviously at this stage, I don't know if your case is gonna go if it is announced that week. I don't know what the priority will be, but that's when it's set. Currently, I don't want to go out that far necessarily. I'm gonna go out about another 30 to 45 days. Angela, if we could get a date for another status.
April 7th at 2:30.
April 7th at 2:30.
Yes.
Does that work for everybody's calendar? And that'll be by Zoom again.
Your
I can do
Honor,
that.
I believe we kind of set that initially. I have a petition for a contempt order on this case that we will be filing hopefully this week.
That is when we set the contempt.
And I believe that has to be in person.
Okay, well, we'll set the status and contempt all for April 7th at 2:30 in person rather than Zoom.
Yes, Your Honor.
Do we need a court order to get a therapist report, or Ms. Cooper, are you confident you can get that resolved?
I
Otherwise,
think so. Before we scheduled this, I had asked her, and she had mentioned 2 weeks. I asked her if she could get me something by March 7th, which is more than 2 weeks. So I think she will. I don't see any reason she won't.
Your
And
Honor,
as soon as I get something, I'll get it out to everyone else.
Mr. Booth, yes?
can I get some information on the March 7th contempt? Because I haven't heard anything about it.
I don't, that's the first I've heard of it.
I can give a brief
April 7th.
April 7th, and it's my understanding that there is a court, there's a petition that's been filed by the mortgage company for foreclosure of the house due to non-payment.
Okay, I suspect you'll be served papers at some point prior to April 7th, Mr. Booth. All right, Miss Boyle, would you mind drafting up another just a brief order that summarizes what's been ordered here today, similar to what you did from the last time?
Yes, Your Honor, I can do that. I did have one request. I don't know, this is something that Ms. Cooper may have to answer. Is she able to talk to the kids' individual therapists?
That's another thing I wanted to address. Thank you. Go ahead and answer that, Ms. Cooper.
Yes, I can do that.
Okay, and do you want that as part of the order of the court that she would be doing that, or do we, I mean, I assume she could do that on her own. I don't necessarily know she needs a court order for that.
Well, I would direct Ms. Cooper that you visit with the individual therapists. And also I want the children to be made available to Ms. Cooper so she can visit with them privately as soon as it can be scheduled.
And I can help facilitate that.
Okay, that sounds good. Just in case you're trying to do it today, my office is kind of half closed because of the weather, but we should be back on track tomorrow. Someone will answer the phone tomorrow.
I'm hopeful too. My
Okay.
office has been half open, half closed. We got in today.
Thanks.
And-
Yeah,
And
me
I
too.
recognize that everybody's schedules are busy, but the sooner you get on to at least the scheduling process, we can get, hopefully, can be receiving a lot more significant information for me to work with moving forward. So, all right,
Your Honor.
Mr. Booth, anything further?
Yes, Your Honor. Can we also get put in the court order that Ms. Cooper be allowed the documentation of Harley's hospitalization and the crisis that he went to, as well as all the kids' school records, as far as like behaviors and stuff like that? That should be granted access to those.
Ms. Cooper, is that something you would normally want to access in your role? as
Yes, and I think
marshal?
I guess I didn't look to today again to make sure. I think we already have an order indicating that, but if that language is in the latest one, that'll help me if someone gives me trouble, but I haven't had any issues talking to anybody yet.
All right, anything further, Mr. Booth?
No, Your Honor, just, 1 second, hold on, I wrote notes, so. Your Honor, as far as, current living conditions of the children, due to the concerns of, as I said, with the behaviors, Harley has ran away, the suicide, there's multiple concerns for the, mental health and their, like, well-being, to include Liliana has been arrested for, a curfew violation, which supports a lack of supervision. I'd request that the court possibly look at maybe finding a temporary living condition until everything can be addressed and all that information is revealed.
Well, Mr. Booth, something like that has to properly be brought before the court by way of a motion. Right now, I'm wanting to get, based on everything that I've heard today, that's why I want a therapist report. That's why I want the children to visit with Miss Cooper, so I can figure out what exactly is going on. If some of those decisions need to be made, then they need to be made, but I don't have sufficient information in front of me to make those kinds of orders right now.
All right, Your Honor.
Ms. Hoyle, if you could get that order from today's hearing drafted, if we can get all this stuff moving, hopefully come April 7th, we'll have a better idea of what we need to do to get this case resolved.
Yes, Your Honor, I should have the court order at least to the parties for approval probably by end of day tomorrow would be my guess.
Okay. Very good. Well, thank you, everyone. If there's nothing further, we'll be in recess. Have a good evening.
You too. Thank you.
Thank you.